Arbor One versus Rico McGuire. Et al.
Your Honor, Minnie Kim on behalf of Mr. McGuire, as well as all of the other.
Good morning, Your Honor. Deputy Gordon Lang here on behalf of.
All right. Where are we on these, man? Can I dismiss them and get them off my caseload?
We're okay with that. At this point, we, as we indicated last time before you, Judge, everybody that was on the docket has been no longer in a hotel. Everybody's been moved. Everybody's been relocated, grown, or moved to alternate housing. So there's no longer an issue with any of those tenants. The property's actively undergoing remediation.
Wait, did you catch that? All tenants have supposedly been moved out. Except, plot twist, not everyone agrees. Keep your eye on that contradiction. It's about to become a sticking point.
We've still got the two buildings, 720, 721 West Clark, 720 Green. They are ready. We are still waiting for the city to allow us to have our COCs. Everything on the COC list has been done with the exception of two things that the city is requiring Arbor One to do, which is still air quality testing, which we are before Judge Simpson dealing with that. They are also requiring us to place baseboard covers that are fully functioning, but for cosmetic reasons. And there's also an issue of remediation of 4 small areas in the unit that did not pass the spill test. Those are the only things remaining in these buildings. We would, at this point, there are no health and safety issues from the property management team's perspective. So there's no reason these units should not be occupied, but the city is pushing back on that. So we have not gotten COCs yet. They've started the process on the next 3 buildings, 1431 LaForge, 1433 LaForge, and 772 Green. So they're working on those. Property management team says timeline from when we started should be 7 to 8 weeks. Could be less, half the time and half the money without the requirements the city is placing on us, but we work with what we're given. So they're actively working and they're moving down the list to the next buildings.
It starts to get messy. One side says everyone's gone. The other says not so fast. When even the lawyers can't agree on the facts, you know the court's about to dig in.
So things are ongoing.
No. All right. So, go, Ms. Kim.
Your Honor.
Yeah, go ahead.
I don't think it's correct that all the tenants have been relocated. I know that, for instance, Mr. McGuire is still looking for other housing. And I'm sure the court is aware of Judge Simpson's partial preliminary injunction, allowing the tenants some options to relocate.
But yeah, and I don't mean to interrupt you. Is that where there was the agreement that the tenant would sign that they would leave and then?
Correct.
Okay.
And I believe we had last had some emails with Anne about what the court required for the release of escrow, whether they can just submit the move out agreement, the court order move out agreement, or whether they have to file a motion with the court.
And I don't know I don't know how Ms. Wadling responded, or did we respond to you on that?
I think that you were waiting for a copy of the order, and
right, because I think that was right before a hearing. But so there was one case. I'm good. There was one case where what we did is the tenant came up, provided the agreement to us. It was signed off both by, I think, Beal and by the tenant. I read the agreement.
This is actually a big deal. Judges love efficiency. And here the court is basically saying, don't waste my time with unnecessary motions if we can handle this with a simple order. Legal tip: always check if your court offers simpler routes like this.
The agreement made sense as to what it was saying. And so then I issued an order releasing the escrow pursuant to the agreement and attached it.
Correct.
That is how I thought all of the other ones that were going to happen that did that would take place.
So they do not need a motion. They just need to.
I don't, somehow or another, it has to be, they don't really need, I mean, I hate to go through the whole process of filing motions on it because it is rather straightforward. Just so you know, the young lady that did the other one, she brought it up to the court. Clerk didn't know what to do with it. Got it to us. I read it and then I did the order. Okay, because I understood what was going on. Would I need a formalized motion? No, but would I need some way to recognize that we're receiving it? Because if it's what that person did, I'm going to issue the same order. I mean, it's not like we've got to reinvent the rules.
Tenants and the tenants union about what the court needs with that document, if there's anything additional.
No, but I just have to have something that says I'm submitting this stuff. You see what I mean? I mean, I can't just have loose paper flowing
Like
in.
a cover letter, you're saying?
Yeah, that's fine. And just direct it. Or if you know the tenants, they could just send, you guys could send us an email asking us to issue an order releasing the escrow. Okay.
And
I just want to make it as simple as we can.
And I just wanted to add to Sister Council's summary that I just got an update from one of the city's attorneys this morning about the process of the administrative reviews, where those are. And apparently Arbor One lost the appeal to the County Board of Review, Construction Review. And also, I guess the other appeal before Judge Conkey is still pending. And at the hearing on Friday, there was testimony taken about the air quality testing, and that evidentiary hearing is continuing on July 10th, I believe, at 9 a.m. And there was some discussion about whether...
And here's the drama tenants who did what the court asked are now being sued for eviction. That's wild. Who's really at fault here? Drop your take in the comments. Is where the ethics get murky.
There should be a neutral, not neutral, but I mean a outside third-party inspector involved in all of this. And a conservator was appointed last week. An order is about to issue soon. I think those are the additional updates that I can think of. There is one other concern, Your Honor. A lot of the people that were relocated by Arbor One to the villa side, are you aware?
Go ahead. I'm listening.
They're paying money into escrow as this court requested, and they're being sued for eviction in 14B.
Correct.
Court. And we are representing a couple of them, but it's a big concern.
I had talked to Judge Washington about that, right? Because now these cases are flowing over into various jurisdictions. Certainly, I think that those issues could be resolved in one of two ways. One would be to file with this court an order to either transfer, if all the issues are resolved, we would just pay out what's in our escrow to the landlord.
Resolve
Okay.
that way.
I mean, if the tenant's suing the landlord, the new landlord, that's in the 14B jurisdiction, the villas, and all the issues are resolved, it's just an issue of money, then in order to this court saying that can be paid to the villas, I would sign off on something like that. If the issue is that there's going to be some litigation surrounding that, then it would seem to me to submit an order just requesting that this court transfer the escrow to the 14B district court on whatever that case number is.
I'm not quite following, Judge. So these are non-payment eviction cases where the tenants are paying their rent into court escrow here. So
Correct.
You're saying you want the escrow just transferred to 14B?
There's going to be one of two things that are going to happen with the escrow. I guess there's a third option. Either the escrow is going to be subject to the order that Judge Conkey issued.
Notice how fast the court shifts the tone. If you're relocated to a livable place with proper certification, the judge expects full rent even. if you never plan to stay. That's how legally binding a Coke can be.
Regarding the distribution of that, because that person has technically given up their other unit. So under that order, it may have to go to the tenant.
So under Judge Conkey's order, if you have asked Arbor One to temporarily relocate you, then
It's
you're not getting
50%.
a refund of the monies right now.
I thought it, as I read it, it was 50%.
They're supposed to be paying, if you're asking for temporary relocation with the intent of coming back to
Right.
Arbor One, when you place in a unit that has a COC, or when your unit gets a COC, whatever that winds up being, they should be paying 50% of their rent from wherever they're relocated to.
Right.
If they're being relocated permanently with no intent of coming back to Arbor One, and they're being relocated to a place that has a COC, there's no reason why folks should not be paying rent in a unit that has a COC. Judge Conkey's order is very clear that rent is only abated if there's no COC. So if these folks are intending on staying wherever they are, they should be paying full rent to Arbor One. And I will say, Your Honor, we are not handling the township side, so I can't speak to any of the actual.
Of course not,
that have been
right?
filed. But I would presume that if they're not paying the rent to the landlord and they're intending on staying there
Okay.
long term, that's
This-
why the eviction is filed.
I
And
disagree
right,
with-
that's, go ahead.
I disagree with what, first of all, there's nothing in Judge Conkey's order about paying 50% of.
Oh, no,
Yeah.
that's the way I read it. The agreement was that if they were voluntarily surrendering the unit without an intention of coming back, they would get all, for our purposes here at 14A, they would get all of their escrow. Right?
If they're giving up and not coming back.
If they're giving up and not coming back. The part I didn't know what to do with, because my understanding was there's this 50% split, is that if they went someplace else, I don't know what to do. There has to be an order or something submitted to the court as to what to do with that escrow. Because my understanding is there was this 50%, which I didn't understand, but it wasn't my order. There was the 50% split to, let me see if it's in this tenant.
There was some discussion, Judge, about the 50% because tenants who are placed in hotels had no way to cook their food, etc. But I don't think that language made it into the order.
It's not in the optional move-out agreement. I can tell you that much.
Judge Conkey was very clear on the record that her intent was to have residents who are requesting to be temporarily relocated pay 50%. She very clearly asked legal services, Blue, I believe specifically, whether or not she would rather not include anything in the order with regards to temporary relocation and kind of let it be what it may, or consider or order that tenants pay 50% of their rent and make that decision.
It might have just been an oversight, but it's not in the order. But I would have to say that I believe the tenants
I don't
that
know
are in
that
your
that,
court are paying, actually, I think they were paying their full rent into the court escrow here.
correct, because because the allegation that was raised was that they were being relocated by Arbor One to the villas in the township. There were issues that were raised as to the fitness of those units. Okay? I don't know anything about that. Those aren't my cases. So the tenant asked me, what should I do? I said, well, we have the escrow open. At that point, there's no case at 14B. I'm aware of that. So I said, just continue to pay your rent here with the thought process that could be the financial pieces could be straightened out rather simply by virtue of an order. If they were sued in 14B and there's an issue, I don't know why you couldn't submit an order to the court just asking us to pay those funds over to escrow in 14B.
So From what I understand, Judge, the tenants that have been relocated to the villas, some may have signed leases to stay there permanently, but the tenants that we're representing, they're there temporarily until their units get their certificate of occupancy. They're in smaller
Okay,
units
that's
than
fine.
they want to be, or their conditions aren't right, or for instance, there's another tenant who's,
Well, what are you asking me to do though?
I'm not sure what the right thing is, Your Honor. I don't know if 14B should have jurisdiction over those cases in a non-payment case when they have been paying rent.
And now we're knee-deep in legal chess, counterclaims, jurisdiction questions, and who really has the right to collect rent. It's not just about the money, it's about who controls the board.
There shouldn't be a non-payment eviction filed at all.
And that may be, I agree with you in the sense that that may be your defense to their claim. When they filed the case in 14B, your defense of that is they've been paying their rent all along.